Welcome back, finance fans. Let us begin this third segment with account sharing. Sharing in accounts and guarantees. Employees of FINRA and MSRB member firms are generally prohibited from sharing in profits or losses from their customers' accounts. However, an exception is made if the following conditions are met. The employee has made a financial contribution to her customer's account and shares in the profits or losses directly in proportion to her contribution. This does not apply to situations where the employee has an account with an immediate family member, for example, a joint account with a spouse or a parent. The customer's prior consent is given. The employing broker-dealer's prior written consent is given. Investment advisory accounts. An exception to the prohibition on sharing in customer profits and losses applies to investment advisory accounts where a fee is charged. To qualify for the exception, both the employing firms and the customer's prior written consent are required, and the firm must comply with SEC regulations related to investment advisory services. Guarantees. Employees of member firms may not guarantee against losses in customer accounts or transactions nor reimburse a customer for any losses incurred. Borrowing and lending practices with customers. Registered representatives are generally prohibited from borrowing money from or lending money to a customer. However, such practices are permitted if a member firm implements written procedures and satisfies at least one of the following 5 provisions. 1. The customer and the registered person are immediate family members. 2. The customer is a financial institution regularly involved in the business of extending credit or providing loans. 3. Both parties are registered with the same firm. 4. The loan is based on a personal relationship between the customer and registered person. 5. The loan is based on a business relationship that is independent of the customer-broker relationship. If any of the conditions in provisions 3, 4, or 5 are met, the registered person must notify the firm before entering into these arrangements. The firm is also required to provide written pre-approval of these arrangements and maintain the approvals for at least 3 years after the arrangements are terminated. If the registered person involved in these practices is terminated, the approvals must be retained for at least 3 years after termination. Financial exploitation of specified adults. FINRA Rule 2165. FINRA created a hotline for seniors who have questions or concerns about their brokerage accounts. One of the major issues highlighted by these investors was suspected financial exploitation. To address this issue, FINRA established Rule 2165 titled Financial Exploitation of Specified Adults. Specified adults. According to FINRA's rule, the term specified adult is defined as any person aged 65 or older. Any person aged 18 or older whom the firm reasonably believes has a mental or physical impairment that prevents them from protecting their own interests. This determination should rely on the facts and circumstances observed in the firm's business relationship with the person. To assist these specified adults, FINRA has established a process for firms to respond to situations where they have a reasonable basis to believe that financial exploitation has occurred, is occurring, has been attempted, or will be attempted. This process includes appointing a trusted contact person. Firms may reach out to a customer's designated trusted contact person, and when appropriate, place a temporary hold on disbursement of funds or securities from the customer's account. A trusted contact person must be 18 or older and is essential in helping the firm protect the customer's account and its assets, as well as responding to potential financial exploitation. The trusted contact person's name and contact information, mailing address, phone number, and email address will be part of the customer account information that should be obtained when a member firm opens or updates an account. Although providing the trusted person's contact information isn't required to open the account, a firm should make reasonable efforts to collect it. Financial exploitation. According to FINRA's rule, financial exploitation includes the wrongful or unauthorized taking, withholding, appropriation, or use of a specified adult's funds or securities, or any act or omission by a person, including through the use of a power of attorney, guardianship, or any other authority regarding a specified adult to obtain control over the specified adult's money, assets, or property through deception, intimidation, or undue influence, or convert the specified adult's money, assets, or property. Temporary hold. The rule allows a firm to place a temporary hold on the disbursement of a specified adult's funds or securities, but not on their securities transactions. Although the hold will not apply to a customer's sell orders, it will apply to any request to send the proceeds of a sale to another person if there is a reasonable belief of financial exploitation. The temporary hold will apply to both a single disbursement and a transfer of an entire account, ACATS transfer. However, if the firm places a hold on an account, it must allow disbursements if there is no reasonable belief of financial exploitation, for example, normal bill paying. Account movement between accounts at the same firm. The temporary hold also applies to transferring assets between accounts at the same brokerage firm. For instance, this hold is relevant when a relative or friend of an account owner attempts financial exploitation by initiating a transfer of assets to their own account at the same brokerage firm. Reasons for the hold. If a member firm places a temporary hold, the rule requires the firm to promptly begin an internal review of the facts and circumstances that led it to reasonably believe that financial exploitation of the specified adult has occurred, is occurring, has been attempted, or will be attempted. Notification of the hold. By no later than 2 business days after a member first places the temporary hold on disbursement of funds or securities, the member firm must provide notification, either orally or in writing, which may be electronic, of the temporary hold and the reason for it. The notification must be provided to all parties authorized to transact business in the account, unless a party is unavailable or the firm reasonably believes that one party has engaged, is engaging, or will engage in the financial exploitation of the specified adult, and the trusted contact persons, unless they are unavailable or the firm reasonably believes that the trusted contact persons have engaged, are engaging, or will engage in the financial exploitation of the specified adult. The rule intends to prevent a firm from dealing with individuals who might be exploiting the specified adult. For example, if the adult child of a senior investor is the trusted contact person and might be misappropriating funds, it is not prudent for this person to be contacted. Before placing a temporary hold, it is recommended that the firm first attempt to resolve the situation with the customer. However, if a temporary hold is placed, the firm is required to notify the trusted contact person. Once a temporary hold is initiated, the firm may only terminate it after contacting the customer or the trusted contact person to discuss the situation. The customer's objection to the temporary hold or information gained during the discussion with the customer or trusted contact person may assist the firm in deciding whether to maintain or lift the hold. Period for the temporary hold. A temporary hold will expire no later than 15 business days after it is first placed on the account, unless terminated or extended by another authorized regulatory entity. If a member firm's internal review supports its reasonable belief that financial exploitation of the specified adult has occurred, is occurring, has been attempted, or will be attempted, the firm may extend the temporary hold for an additional 10 business days, unless otherwise terminated or extended by another authorized regulatory entity. Accounts at other broker-dealers and financial institutions. For supervisory purposes, member firms must monitor the personal accounts that their employees, both clerical and registered personnel, open or establish with firms other than their own. For instance, if a registered individual from DF Brokerage LLC seeks to open an outside away account to trade securities at another financial institution, both the employee and the firm are required to follow specific rules before the account can be opened. For the purposes of this rule, the term financial institution refers to a broker-dealer, investment advisor, bank, insurance company, trust company, or investment company. Employee requirements. Employees intending to open outside accounts that may facilitate securities transactions must obtain the prior written consent of their firm. Furthermore, before an outside account is opened, employees are required to inform the executing firm in writing of their association with another member firm, related and other persons. This rule also applies to accounts through which securities transactions can be executed and in which the employee has a beneficial interest, including any accounts held by the employee's spouse, the employee's children, if they reside in the same household as or are financially dependent on the employee, any related person over whose account the employee has control, and any other individual over whose account the employee has control and to whose financial support the employee materially contributes. Previously opened account. If an employee opened an account prior to becoming associated with a broker-dealer, the employee must obtain written consent from their employer within 30 days of starting their employment to continue maintaining the account. Additionally, the employee is required to notify the executing firm in writing regarding their employment with another broker-dealer. Once an account has been opened for a member firm employee, the executing firm is not obligated to get the employing firm's approval before executing each order. However, the employee's activities are subject to any rules or restrictions set forth by their employing firm. Executing broker-dealer requirements. Upon written request, the executing firm must provide duplicate copies of confirmations, statements, or any other transactional information to the employee's broker-dealer. Exemptions. The requirements of this rule do not apply to accounts that are limited to transactions involving redeemable investment company securities, mutual fund shares, unit investment trusts, variable contracts, or 529 plans. Payments to unregistered persons. A broker-dealer is not allowed to pay any form of compensation to another broker-dealer or a person associated with another broker-dealer unless they are properly registered. The term compensation is broad and includes commissions, discounts, concessions on new issues, and fees. Retiring representatives. If a bona fide contract is established, a member firm may continue to pay commissions to retiring representatives after they leave the firm, but only for their existing accounts. The contract language between the retiring RR and the firm must clearly state that the RR is prohibited from soliciting new business or opening new accounts. Forgery. The act of forgery occurs when one person signs another's name on a document without authorization or causes another person to do so. Clearly, forgery is a serious offense that may result in criminal prosecution and regulatory sanctions. RRs must also take care not to unintentionally commit technical forgery. This occurs when a well-meaning representative signs a client's name to a document under the belief that they have the client's authorization. Books and records. Record-keeping formats. As explained in a previous video, broker-dealers are required to maintain records for a specific number of years after they are created. The SEC permits keeping records in forms other than paper. For instance, firms may store their files on micrographic media or electronic storage media. Micrographic media encompasses microfilm, microfiche, or similar methods, while electronic storage media includes methods of digital storage, for example, CD-ROM. If a firm opts to use electronic storage media, it must notify its primary regulator before doing so. Additionally, if a firm changes the type of electronic storage media it is currently utilizing, it must inform its regulator at least 90 days prior to implementing the new method. When maintaining records using electronic storage media, the firm must keep records in non-rewritable and non-erasable formats. Automatically verify the quality and accuracy of the media recording process. Maintain records in serial form with time and date information that documents the required retention period for the stored information. Be capable of downloading the indexes and records to any medium accepted by the SEC or other SRO to which the firm belongs. In addition to the aforementioned requirements, a firm that uses micrographic or electronic storage media must establish a location from which the SEC and the firm's SRO can promptly review stored files with duplicates readily available. All duplicates of the maintained files must be stored separately from the original records. The records, originals and duplicates, must be accurately organized and indexed. The indexes should be duplicated, stored separately from the originals, and made available for examination by regulators upon request. FINRA and the MSRB also have record-keeping requirements for any books and records not specifically referenced under SEC rules. For FINRA, the requirements are outlined in Rule 4511. For the MSRB, the requirements are detailed in Rule G8, the records that must be kept, and Rule G9, how long the records must be kept. Conclusion. This concludes the segment dedicated to providing information about securities-related activities that are considered prohibited and illegal. Much of the focus is on market manipulation, insider trading rules, FINRA's IPO regulations, sharing in customer accounts, borrowing or lending to clients, exploitation of seniors, and record-keeping. The next segment will review the regulations that apply to the associated persons of member firms. As we conclude this segment, we encourage you to show your support by liking this video and subscribing to our channel. It only takes a simple click for you, but it means significant support for us, and it is completely free. Please turn on your notifications to be among the first to experience the next segment. Thanks.